Members and officers and physical attendants with an electronic device muted to avoid feedback. Please, with any remote participant, keep their cameras and microphones off unless they wish to speak. The meeting may be recorded and data collected during recording of the meeting will be retained in accordance with the council data protection policy. The record of the meeting may be added to the council website. Members accessing the meeting in Oakridge use their Scarborough Council or Cape Town Council laptop to participate virtually. If you join using the link on the website or on a mobile or tablet device, it may not always be possible to identify you, and you may not be recorded as in remote attendance. I welcome everyone to the licensing subcommittee meeting. Item 1, emergency evacuation procedure. There is no scheduled test of the fire alarms during this event. If the alarms do sound, please leave the building quickly without collecting any of your possessions. Using the door sign as fire escapes and assemble in the car park at the front of the building. Await instructions from the fire marshal before returning to the building. Should anyone require assistance in evacuating the building, please make the volunteer staff in front of the office aware of any special needs so that suitable arrangements may be made in the event of emergency. Are there anyone that may need assistance? Thank you. College for absence.
Thank you, Chair. Very good.
Thank you.
Yeah.
Oh, God. Hang on.
Right. My name is Councillor Derek Carnell, the chair of the subcommittee. To my right is
Councillor Simon Clark, member of the licensing committee.
Councillor Leanne Moore, member of the licensing committee. I'm Helen Ward, legal advisor.
Julie Hathaway, Democratic Services.
I'm Jo Thomas, licensing team leader.
declarations of interest, are there any declarations of interest?
Yes, Chair. Having read through the bundle from the applicants on page 100, your bundle, there is a character reference from a Mr. Femiosi. Mr. Femiosi is known to me through my participation in membership of the Labour Party. However, I'm not known to the applicant or the previous applicant who was subject to the Home Office raid. My knowledge of Mr. Oakley doesn't prejudice my view of the application in any way.
I'm very grateful, and I certainly would not ask you to do anything but
Thank you. Could I ask you to introduce yourself?
Harry Taylor, Chief Immigration Officer from the.
I'm Spud, I'm the expert witness.
Gary Grant, barrister acting for the licence holder.
Elton Ackers, licence holder.
Fabian Superlast, consultant.
Thank you very much. Can I confirm that all parties are aware of subcommittee's hearing procedure and that each party has a copy of the hearing procedure document? The subcommittee will allow all parties to put their case fully and make full submissions. The subcommittee procedure shall take the form of a discussion led by the subcommittee. Where any person attending the hearing behaves in a disruptive manner, the subcommittee may direct that person to leave the hearing, including temporarily. All subcommittee members have pre-read all the papers and any other documents contained in the report regarding the hearing. Could the licence officer please introduce the report?
Members are asked to determine an application for review of a premises licence under the Licensing Act 2003, served on the council by Home Office Immigration Enforcement Officers. This review is brought on the grounds of the licence of objective prevention of crime and disorder and relate to an immigration enforcement visit to the premises that took place in January this year. The review application brought by immigration is shown within the agenda as Appendix 2 on page 19. The redacted application pack can be seen as Appendix 3 on page 25 and 54 of the agenda. The unredacted documents have been circulated to the premises licence holder and members prior to today's hearing. During the visit to the premises, immigration found 2 persons working who had outstanding claims for protection and a 3rd worker who had overstayed their visa. Under provisions contained within the Immigration and Asylum and Nationality Act 2006, an employer must check the immigration status of persons that they employ. The relevant sections of the Act are shown within the agenda, starting on page 55. There is guidance available on the Gov.uk website to inform employers of their responsibilities in this regard. During the consultation, 1 representation was received with comments in support of the review. This representation can be seen as Appendix 5, page 65 of your agenda. The premises licence holder's representative has submitted a portfolio of evidence that has been provided in advance to the subcommittee and immigration. As part of the review application, Home Office Immigration have the opportunity to request of the subcommittee the enforcement action they deem appropriate based on the circumstances. In this case, the immigration are seeking revocation of the licence. Members are requested to determine the application as they think fit. Steps that they can consider are shown in section 6.1 of the report on page 6 of the agenda.
Thank you very much. Can I please ask the Home Office and Immigration Enforcement put their case?
Thank you very much, Chair, and good morning all. Can I first confirm that you've all had a chance to read through of the pack that we submitted? Yes. Perfect. In that case, I won't go through the entire pack for you, but I will make some key points before summarising the case. So the ability to work illegally is a key driver of illegal migration. It encourages people to break the UK's immigration laws and provides the practical means to remain unlawfully in the UK. It encourages people to take risks in trying to enter the UK illegally by putting their lives in the hands of unscrupulous people smugglers and leaves them vulnerable to exploitative employers. Illegal working results in businesses that are not playing by the rules, undercutting legitimate businesses, and it also negatively impacts upon the wages of lawful workers and can be linked to other market abuse such as tax evasion, breach of national minimum wage and exploitative working conditions. Working illegally is considered a criminal offence in England and Wales, and upon conviction, an illegal worker may receive a custodial sentence of up to 6 months and an unlimited fine. Employing illegal workers undermines the licensing objectives, specifically crime and disorder. Immigration enforcement don't just drive around looking for premises to target. We are an Intel-led organisation, so for us to go to a premises, there has to be significant concerns, and all Intel goes through a thorough screening process before we get to the premises in the first place. And we don't routinely seek licence reviews, but we do in cases where we have item concerns. So in this particular case, immigration visited MEMS Meze in Sheerness back in January of this year. During our visit, we encountered three illegal workers at the address. 2 of them had outstanding applications with the Home Office, but no right to work. 1 was an overstayer, again, no right to work. One of the illegal workers stated that he had even produced to the employer a copy of his biometric residence card, which clearly states on there that he could not work. So he had knowingly been employed. We note as well that at least 2 of the workers had been working at the address for at least 12 months prior to our visit, so quite a substantial time. We also point that most of the employees that we encounter working illegally were not actually paid in cash, but were paid in accommodation and food. So a massive risk there and being taken advantage of, in our opinion. So we understand that at the time of the visit, the DPS was not actually running the business hands-on and she'd leased it out to another company. However, we note that she's an experienced license holder and with 20 years experience. So we would expect that she'd know that as a license holder, she is responsible for ensuring that the licensing objectives are upheld, regardless of whether she's running the business herself or whether she's leased it to somebody else. She should be making sure that them objectives are being upheld, which she has clearly failed to do by leasing it and taking a hands-off approach and not having any day-to-day dealings. We'd also point out that guidance within licensing does say that the DPS, where possible, should have day-to-day handlings with the premises so they know what's happening, so they can keep up the objectives of the licensing acts. We'd also point to the fact that on the 16th of May, she gave an interview to local media where she actually admitted to the media that she was still employing one of the illegal workers. So,
Sorry,
once
has this been submitted in evidence?
Yes, sorry.
At a hearing, if parties want to introduce new evidence, parties be able to have the news report that you're referring to occurred after documents. And because there's been no further submissions from the Home Office, that can't be and if you do, they won't be able to put any weight on it.
Okay, that's fine.
Could I just, on that point, and I'm grateful to Mr. Part of our case, and I'm going to mention it, is there's been misleading reporting of this case to the detriment of my client. So the Home Office seeking to rely on a local newspaper report, it is an unfortunate approach for them to take.
Well, as I won't mention the news reporting any further, but the point still stands that as somebody with 20 years experience as a licensee holding a license, she should have known better than to not know the day-to-day ongoings in the restaurant, which she owned and which she was the DPS for. If she wanted to take a hands-off approach, she should have sought to get a new DPS put in place that would have undertaken all of these relevant checks and made sure the business was running as it should. That sums up everything for now. Thank you.
Thank you very much. Any questions?
Ms. Sakis, so to the Home Office guy, I'm sorry, no chair, nothing for the Home Office.
Anything?
No.
Yes.
And Mr. Taylor, you, well, the Home Office issued the fine against ET Meze.
Yes, that's
How
correct.
did that decision come about?
So
That company?
that decision would have been made by our civil penalty team, which is a completely separate process to the licensing process. So that would have been issued to the responsible person that was identified as having given the individuals the job in the first place. But we see the civil penalty process as a separate process to licensing.
Right, so the identification of that company was done by a different team, so you're not able to advise how they came to that decision.
That would be correct.
Do you know if that penalty is going to pay us?
As far as I'm aware, it has not.
It's simply this, Mr. Taylor, is it right that of the illegal workers who were questioned, for those who were able to give any full detail as to who the owner of the premises was, they gave the name Mr. Erhan Deliklitas. Is that correct?
I believe that is who they gave as the owner of the premises.
Thank you. Those are all my questions.
But again, I would add that that would have been for civil penalty process, not the licensing process, which is a completely separate process.
Thank you.
Could you please give your?
The Home Office, the country, its council rightly takes illegal working seriously for all the reasons the Home Office gave. And nothing I say today seeks to mitigate the seriousness of that sort of behaviour. The Home Office have amassed a great deal of paperwork they've served in this review. They've compiled it, they've sent it in, but I regret to say they have fired the missile at the wrong target in this exceptional case. And the reason has already been alluded to. My client, I'm not putting forward perfection for her. She made a mistake in that she didn't sufficiently supervise her tenant. But she was not the employer of the illegal workers. And the Home Office know it, and the Home Office as an entity accept it. And we know that because, as you've heard, the illegal workers who were there gave a name, Erhan Diliklatas, as the owner. None of them gave my client's name, Elvin Akers. She's not mentioned in that paper. In addition, the Home Office as an entity, and an act by one unit in the Home Office is to be taken as a matter of law of an act by the whole Home Office. They issued correctly the civil penalty notice amounting to £120,000 to the employer. Who do the Home Office say is the employer? It's not my client, Miss Akis, the license holder. It is, as they correctly identify in their paperwork, it is EDT Metse Limited, the registered business owner. What do we know about EDT Metse Limited before I come to my client's links with them and how they got? I've handed in 2 additional documents, and I'm grateful there's no objection to that being considered. It just closed a small hole that I thought would assist you to know about the company. So EDT Metse Limited, the owner, and according to the Home Office, the employer of the illegal workers, has 2 officers listed. Now, the first is Mr. Barak Memmadov, and it's suggested on the face of this document, he was appointed on the 1st of January 2025. The second is Mr. Erhan Diliklatas, who I'm going to suggest is the baddie in all this. It suggests he resigned on the 1st of January 2025. The second document clarifies when he actually resigned, albeit he backdated the forms. So the second document, the TMO1 document, once again from Company House, you can see the dates that the application, the termination of Mr. Diliklatas as the director came in, 16th of April 2025. In other words, after the Home Office's visit. What's happened? Well, what's happened, probably all had the opportunity to read Ms. Akers' statement in the bundle, and that sets it out in detail. And I'm not going to go through every detail, but I can summarize that Ms. Akers in this case has run licensed premises in either Sheerness or Sittingbourne for some 21 years, since 2005. She has a second premises, and this is in Sheerness, High Street, Sheerness. It's a cost-cutter convenience store where she holds an alcohol off license. She has held that since the beginning of the Licensing Act 2003. In fact, she took it over in 2004. She has held the license for the cost cutter for some 21 years without any issues with the authorities, any breaches of the law or the conditions, or any reviews. She decided to expand her business interests and did so in 2018 by buying the Halfway House pub, which I understand was had old glories but was severely run down. And she invested just about her life savings in renovating it into what is a smart and extremely popular Turkish meze restaurant. And I'll come to some of the character references in a minute. Suffice to say, she turned what was a rundown blight on the community into an asset for the community that they value. And you will see a number of character references from people in the community or who have known Miss Akis for a lot longer, who attest, firstly, to the importance of this venue, and secondly, to her good character. You don't, in fact, need to go to any of our evidence. You'll notice there's a supporting representation for the review from Councillor Mike Whiting, who in his representation, it's either of your agenda papers, but you need not turn it up, says this, while supporting the concerns of the Home Office, says that this restaurant is a very popular and seemingly successful restaurant. So she took over this premises in 2018, converted it and ran it herself, together with her partner, for 4 years. She did so in an exemplary fashion. No breaches, no non-compliance, no issues with employing illegal workers. And that's important because that 4-year period is the proper test of whether my client is capable of running this premises in the future in compliance with all the laws and licensing regime. In March 2022, given she had other business interests and she had young children, one who at that stage I think was just 4 or 5 years old, she decided to focus more on her other businesses and her children. And so she signed over the business, if I can put it informally, to Erhan Deliklitas. He wasn't a stranger. She had worked with him in some of her other premises for a number of years. He appeared to be a capable, responsible person. That turned out to be her misjudgment. So she signed over the lease to them, and just so I can identify the documents in what is a large bundle we served, you will see the lease agreement beginning, this is in the license holders bundle, at page 26. Now, this 29th of March 2022, this is the lease relating to the Halfway House, that, as you know, was the name of the old pub. It's one she's retained on the fascia, between ADS Property and Management Limited, that is the business company of which Miss Akis is the sole director, and Erhan Deliklitas, the man who the illegal workers on the visit in January said was the owner. And that lease, which goes to some 40 pages, includes the usual term that it is the responsibility of the leaseholder. Do you have a break? Certainly.
We've all got the same, me and him got the same bug. Right. That one I can. Oh, thank you.
So I was about to mention that the lease contains the usual clause within it, that it is an obligation of the leaseholder to ensure they comply with all of the laws that they need to comply with. Now, I do not suggest that that means that there is no responsibility properly on the shoulders of Miss Akis. There is. What she ought to have done, as she says in her statement, she ought to have either transferred the license or she should have varied the DPS position from herself to someone, saying as she was not in day-to-day control. she relied on the advice of a firm of solicitors who were not a specialist firm of licensing solicitors. And they didn't advise her as to it, and she was left with the impression that she had to retain the license in her name. It was bad advice, and it's no great surprise, and there is paperwork from those, a former employer of those solicitors, who indicated that the solicitors regulatory body had to close that company because of issues with the way it was being run. In other words, they were not blue chip licensing solicitors. So she never got the advice she should have done. And that's her mistake. She stayed as the license holder. She stayed as the DPS when she shouldn't have done, because she didn't have oversight over what was going on or day-to-day control. Now, the very fact that she remained the license holder is not perhaps as staggeringly silly as it may seem when you consider that the biggest pub companies in our country, the biggest, Stonegate pubs with 4,500 pubs, in fact operate the same system. Whereas the landlord, Stonegate, or in my client's case, Miss Akis, the landlord keeps the license, and then a tenant operates the venue under that license. That's not unusual, and there would be nothing wrong in that. However, what Miss Akers should have done is, if she wasn't going to be the day-to-day manager, she should have transferred the DPS position to the person who was running the company. The height of her error is that as license holder, she did not sufficiently supervise her tenant. And the question for you is, what are the consequences of that admitted error? Well, the Home Office, perhaps somewhat unimaginatively, say the only option for you is the permanent revocation of this license. And we suggest that the best cure for a headache is not always a beheading. There are other paths and powers open to you to properly reflect the facts of this case. And those are the ones I'm going to come to towards the end of this presentation. And they fall short of revocation, because revocation is neither proportionate nor necessary nor appropriate in this particular case. To support that submission, I'm going to point to a number of factors within our evidence. The first is the Home Office's acceptance that my client is not the employer or the owner of this business at the relevant time. The second is that it is surprising that the Home Office would seek and claim it is the only valid outcome of this hearing, revocation, when they did not pursue this review with any urgency whatsoever. The inspection where the legal workers were found was on the 16th of January 2025. The Home Office did not apply for the review until the 30th of April, 3.5 months later. That is not a case where, if the Home Office had such serious concerns that this matter cannot carry on, it must be revoked, you may ask yourselves why they took 3.5 months to launch the review. Next, you would see within the character references within our bundle. I'm just going to, I know you've had a chance to read them, so this is simply for your note for the ones which you may find most assist you in your ultimate assessment here. And your ultimate assessment is this. It's not, how do we punish Miss Akers? If you need to punish, she needs to be punished. She would be taken down the civil penalty route or to the magistrates' court. But that's not the role here of a licensing regime. You can indeed take steps that deter such action if you think there is any further action needed to deter Miss Akers, and we suggest there isn't. But ultimately, your role today is a future-looking one. It is to look and to recognise the facts of the past, but ask yourselves, what is appropriate and proportionate in order to ensure the licensing objectives are promoted in the future. And to do that, it's important to know the measure of the woman you're dealing with. And that is the reason that we have put in a number of letters of support from extremely responsible people who have known Miss Akis for longer than the Home Office have, and indeed for longer than this subcommittee, or indeed the lawyers on her side have. And I'm going to give you some page references, which we ask you to reconsider, please, when you retire. There is firstly the letter from her accountants, who have dealt with her for a number of years, and this is Ulis Limited at page 83 of our bundle. And it speaks of how important compliance is for their working relationship with Ms. Akis over the years. There is a letter at page 85 from Paradigm Solicitors, who say much the same thing, that this is a person who can be trusted in her business dealings according to their dealings over the years. Extremely unusually, you have not one, but two references from serving police officers. At page 87, you have a reference from a serving police sergeant in the Metropolitan Police who has known Miss Akis for a number of years. And at page 90, you have a reference from a serving police constable who has known Miss Akis since childhood. Sergeant says expressly at page 90 that this is the first character reference he has ever agreed to write in his career. Police officers are slow to do so, for obvious reasons. But he sees this case, because of his knowledge of Miss Akis, as one where he had to put his head above the parapet and say, this is not a bad person, this is a good person. And I say that in those stark terms because, as I alluded to earlier, there has been some really regrettable news reporting of this matter in the local press that is positively misleading and paints Miss Akis's character in a bad light based on information the reporter did not have, which is why it was unfortunate to hear the Home Office attempt to quote it. There is a former mayor of the London Borough of Enfield at page 97, who has known her and indeed has dined at Men's Metzi. Significantly, that individual is a former chair of the licensing committee in the London Borough of Enfield. So he knows that of which he speaks. He speaks of her character and her community and charitable work in the local areas. There is the member of the local Labour Party, known to one of the members, at page 100. There is a solicitor from the government's legal department at page 102. And there is a US attorney who used to live on the Isle of Sheppey at page 104. Dare I say that most of us in this room would be incredibly proud we were able to track the level, quantity and caliber of support from responsible members of the community, from those who have stepped forward to put their thoughts about Miss Akis down in paper to assist you and your assessment today. So having read that, can it really be concluded that Mr. Akis is an irresponsible person? But we suggest no. He's a responsible person who made an error. This is the first time she has ever been reviewed for this license or indeed her other cost cutter license. So it's a first review. This is not someone who's been given a warning. There's no warning letters here in the Home Office pack. This is someone who it's the very first time she's been pulled up on anything in this case. Does that merit the ultimate punishment which the Home Office seeks? We say no, that would be disproportionate. There was nothing in it for Miss Akis to overlook the employment of illegal workers by her tenant. she received, and it's set out in the lease and the solicitor's letter, she received a fixed rent each month from the tenant in this case. That's important because there's no profit element. Sometimes landlords will take a share of the profits, for example, in a lease agreement of this type. This is not one of those agreements. So there's no profit motive whatsoever for Miss Aitken to have overlooked her tenant employing illegal workers. There's almost certainly a profit motive from the tenant, Mr. Deliclitas, to do so for reasons you've heard, but no profit motive at all for my client. Now, dare I say that all of us have and indeed can make mistakes in our professional lives. How would we wish to be judged? Only by the mistake or how we responded to it? Because I ask you to focus, please, on how Ms. Aitken has responded to the facts of this case, because we say she has done everything you would expect a responsible license holder to do, even bearing in the mistake she made of not sufficiently supervising her tenant. Number one, as soon as she heard there had been a visit to the premises, she contacted her tenant, Mr. Taylor. He was evasive. He deliberately concealed the facts of the Home Office visit from her, something he later admitted to her. Please bear this date in mind. The date the review application was lodged was the 30th of April. Before then, in fact, a month before then, in March 2025, just as she heard that there'd been a Home Office visit and illegal workers, but before the Home Office had launched a review or any suggestion of a review, she immediately got her solicitors to terminate the lease of her tenant. And in my bundle at page 81, in fact, page 81 is a letter dated the 4th of June from the solicitors explaining what happened. And I'm just going to refer to that because the dates are important. Bearing in mind the review was not lodged until the end of April. It's about the surrender of the lease for Halfway House, that's Mens Metze. We confirm we're instructed by Mrs. Elvin Akis on behalf of ADS Property and Management Limited in relation to the property. I'll read short. Mrs. Akis first approached us on the 18th of March 2025. And due to the tenant's activities, which might amount to a legal activity, instructed us to terminate the lease dated the 29th of March 2022 between, I'll read short, her company and Mr. Deliclitas, the leaser. And we have then drafted a deed of surrender and the parties executed and completed the same on the 9th of April. And we enclose here the deed of surrender, then deals with some discrepancy on the land registry. But you will see that document, the previous documents at page 73. And that is the deed of surrender dated the 9th of April 2020. And the chronology here is particularly important because you will be familiar, we all, with a poor operator who receives a license review and then desperately tries to take some remedial action, but only reactively. In this case, something else has happened because a month before the Home Office launched the review, simply because word got to this, I think from a staff member, that there'd been this Home Office visit and illegal workers were there. Simply because of that, she already took the steps to terminate the lease of the offender, Mr. Deliclitas. As of today, there is a notice, but as of today, Mr. Deliclitas, the offender, is no longer anything to do with this business. He does not work there in any capacity. He no longer has any business or financial interest in this premises. Ms. Akis rightly, as I dare say you and I would have done the same, is kicked him out as soon as she heard what he was getting up to. Since then, my client has resumed operational control of the business, assisted by her partner. Though she has a number of businesses, in particular the Cost Cutter, she has decided to focus the majority of her time running this restaurant to put things right. So she is, as of today, she remains the license holder and she is the DPS. So she is in full day-to-day control of this premises, and she intends to be until everything is put right and everything is running as it ought to be. In the future, she may get another manager in to assist, but she's not, under any circumstances, just going to leave that person to run the business without her oversight. And bearing in mind what you've heard from those responsible character witnesses, she is someone who I suggest can be trusted to get it right. It's a business that employs 15 people. It is their jobs that will be lost if the license is revoked, because the profit margin for nearly all restaurants, certainly today, lies in the ability to sell alcohol. If you remove that, then the business does not survive and there will be 15 people seeking jobs. I would also suggest that, bearing in mind this was a pub that was run down and not a profitable pub, before Miss Akis breathed life into it, that it is not in the public interest for this to become yet another boarded up old pub premises in Swell Borough Council's district, in common with many other districts around the country. To revoke the license would be to destroy my client's life's work and her family's inheritance, hope to leave the business to her children. You will note that this is an alcohol license, and the problems that has given rise to this review is not related to any licensable activity. I accept the guidance in this case suggests you can take into account illegal working and licensing, but it's not directly related, the offending, the illegal working, to the licensable activity, the ability to sell alcohol. In addition, Mrs. Akis has recognised that, like other responsible operators, she can always do better and she can constantly improve her processes. And to that end, she has instructed Mr. Adrian Studd, who's prepared a report that appears in my bundle at pages 14 to 24. And I'm going to call on Mr. Studd briefly. He has, without embarrassing him, a stellar background in licensing, and he sets it out within our papers at page 14. I will just summarise that before calling on Mr. Studd to explain what he's doing to assist Mr. Akis and to try and assist you to be confident in her abilities. So Mr. Adrian Studd had a career with the Metropolitan Police in which he rose to become a chief inspector in charge of licensing for among other things, the London Olympic Games in 2012. He was an inspector in the Metropolitan Police's famous old clubs and vice unit that looked after all the licensing in Soho and the West End and London. And since his retirement, he has acted as an independent consultant. He's not a consultant whose opinion is for hire. You can instruct him, but if he doesn't like what he'll find, he'll say that in a report, and I can speak from experience. In this case, we instructed him to visit, to consider the paperwork, to meet with Miss Akis, to look at her procedures that she will now put in place now she runs it in regard to worker checks, and to opine on whether he thinks she can be trusted to get this right in the future. So with your permission, I'm just going to ask Mr. Studd to explain what he did, what he found, and what his views are.
Oh, thank you, Mr. Grant. Yes, so I attended the premises on the 10th of June as a result of instructions from the consultancy. And I think it's probably fair to note that at that time, I only had brief outlines of it. I certainly hadn't seen Miss Akers' statement. I don't even know if it had been made at that time. So I went to the premises with an open mind to try and see exactly what had happened, what was behind the Home Office's concerns, quite right concerns, and to make a judgment really from my experience as to how it had come about and what may happen moving forwards, depending on the outcome of this review. So Miss Akers, I thought, was very frank with me, very honest with me. I looked at the circumstances of it and the fact that she had remained the DPS and the licence holder. And I thought that really was, or is, one of the key points to this. And when I pointed out to her that as the DPS, she needed to have day-to-day control of the premises, it suddenly dawned on her, I think, just what had happened, that she had been badly advised, but that's her responsibility to get proper advice. The DPS should have been transferred because she was no longer anything to do with the business. And looking at all the circumstances, I was convinced that that was the case. I asked her about how, when she ran the business, she went about recruiting people, and she was able to explain to me in broad working terms what was required to do checks on people's right to work. Both the manual checks, the Home Office checks, where you have to get the share code, and the checks, specific checks on people with British and Irish passports. And she said to me that she passed all of the information on to her accountants, who conducted the checks for her, and she was confident they did the checks properly. This was while she was running it, prior to 2022. So I wasn't satisfied with that. So the next day, prior to my report, I phoned up the accountants to check. And indeed, they confirmed that while she'd been operating that business, they had done all the checks for her, the right to work check. But unfortunately, once the business had passed to the new owner and operator, of course, that had ceased. So really, as we've heard today, she was shocked, I think, when she found out what had happened. And she was certainly shocked when I pointed out to her the ramifications of her failure to transfer the DPS in particular. So moving forward, she convinced me that she would be taking day-to-day control. She was going to remain as the DPS because she could have that control now running the business, and that the accountants would carry on conducting these checks on her behalf, as indeed they do for a number of businesses. So I formed the view that she would be able to run the premises properly moving forward. There'd be no question about her honesty and her ability to run it in relation to the Licensing Act and the alcohol licensing procedures. I think that's all. Unless you've got any further questions, I can help you with.
I wanted to, before questions, I'm just going to conclude with what our proposals are. And that may be an appropriate moment for questions, if I may. So what to do based with these facts? The unusual fact that the licence holder is not the transgressing employer. Well, the Home Office say only revocation. And yes, the guidance suggests that you should seriously consider revocation among the other options. Not you should revoke, but you should consider it. And of course you will. But extra guidance is given in the section 182 guidance to the Licensing Act. Now, you are blessed to have an extremely experienced legal advisor in licensing who will know this inside out. It's paragraph 11.20, and it reads as follows. And in fact, it's been extracted and put into Ms. Akers' statement. Could I please ask you to turn to page 10 of our bundle? So this is the Secretary of State's guidance for the Licensing Act in relation to reviews. The page 10 of our bundle. Paragraph 46. It quotes paragraph 11.20, which is really the crucial test. In deciding which of these powers, in other words, review powers, to invoke, it's expected that licensing authorities should, so far as possible, seek to establish the cause or causes of the concerns that the representations identify. The remedial action taken should generally be directed at these causes and should always be no more than an appropriate and proportionate response to address the causes of concern that instigated the review. What were the causes of concern that instigated the review? It was the employment of illegal workers. Who was the employer? Not the license holder. What is required to get rid of the offender and ensure there is proper supervision in the future? And that's what we propose. And the detailed proposals are in the next paragraph of Ms. Akerson's statement, 47, where she proposes the following additional conditions to be added to the license as follows. A, Mr. Erhan Deliklitas shall not be permitted to work at the premises, either directly or indirectly. As I said, he's already out, but that future-proofs the license, so there is no way back for him into this venue. B, all right to work checks of employees shall be the responsibility of the license holder. Now that goes beyond the law, because the law requires the employer to do it. And as you've seen in this case, they may not always be the same person as the license holder. But this puts a firm condition, so there can be no delegation of the task or responsibility of worker checks to anybody else. It lies on the license holder, albeit they may get professional assistance to do so. C, for a period of no less than 18 months, the license holder shall arrange for an independent professional inspections of the premises without warning, at least once every 3 months. The inspector shall check compliance with license conditions and confirm the right to work of all employees and make a written report after each visit. These reports shall be kept at the premises and made available for inspection on the request of an authorized officer of a responsible authority. Now, what's the purpose of that? We don't ask you simply to trust Miss Akers. What she will have to do at her expense is employ either Mr. Studd or someone like Mr. Studd to come in at least once every 3 months to carry out the sort of worker checks that the Home Office would carry out and to keep those reports. And at any stage, the council or the police or the Home Office can ask for those reports to be disclosed to them. That's important because it's a constant form of supervision over them until things are right on track. We've suggested 18 months. If you think there needs to be a longer period or a shorter period, then that's something, of course, you can impose. But that we think with those conditions, confident, that will meet the justice of the case based on the unusual facts. Most important, amounts to appropriate and proportionate steps that are likely to promote the licensing objectives. It means that a really popular, valued asset for the community will not close its doors for good. It means the jobs will be retained. And also, we're very grateful for the opportunity to have this say in public, because certainly looking at some of the social media posts and the local press reports and the comments underneath, Mrs. Akers' good name that she's worked really hard over the years since coming here from Turkey and becoming a British citizen, really hard to build up. Her name has been dragged through the mud. And if anything has been most upsetting, it's that. And today is an opportunity for her to have got across what actually happened in this case with a solution. And we ask you, please, to endorse the solution that's been put forward. And we're here to answer any questions to assist the subcommittee.
Just a few years, it's very like 20 years licensing experience. With 20 years experience and didn't know how the responsibilities of the DPS.
Yes, I have all the licenses for 20 years. In that period, I never had a single problem or single issues with my license, with my businesses. I never, even had visited several times, there was no problems. So when there's no problem, you're thinking you live in everything as it is. You can take actions. So nothing was done deliberately. What happened, it was my mistake, and I'm really sorry about that. But 20 years keeping a license without any warnings or issues, I think that should be counted as well.
Yeah, I just, going licensing, DPS, you have to be the one to authorise sales. So
Yes.
you have to be on premises or have, that you've signed an authority to sell
Yes.
with all your staff members, so.
And also, it was the first time I asked lease over to someone with my businesses. I never experienced passing a given lease out to someone. And as Garrett said, like Barrison said, I haven't been advised properly by the legal representative that what I should be doing. Like license was just my responsible. It was mainly, I'm really sorry, I'm just so anxious, so I just.
I just wanted to clear it
Yeah,
up
of
because
course.
knowing the license.
Yeah,
Obviously,
absolutely.
you're the one authorising the sale of the alcohol, so if you wasn't there, the alcohol has been unlawfully sold.
It's,
can I, if I can just clarify there, you do need alcohol sales to be authorised by a personal license holder, it doesn't necessarily need to be the DPS.
Right, sorry.
specific. So there would have been a personal license holder who authorised the sales either the signs and be authorised specific individuals. Or if it was similarly 18%. Yeah, but that would need to be the DPS.
Sorry about
Um. Was there a personal license holder there then?
I get Mr. Delictatas was a personal license holder.
Okay, thank you.
Thank you. I've just got a few questions. In the report, the licensing together, it says that on the on the 25th of January this year, you applied to vary the license to specify limits. So, and essential partner. So why did you decide to go with the yes to limit sales gun on the?
because I've had, he had a phone call from one of the members of staff at the restaurant. And I told him that, Home Office or police officers at the premises took a picture of the license. Because the license is up on the wall in the frame. And because I think they talked about what happened. And he approached me and he said, well, I don't know, but they took a picture of the license. Then I clicked, said yes, then I started searching, what do I have to do? Then I put member in DPS straight away while I was dealing with problems.
Why did you put Mehmet in rather than yourself?
Because he was the only available at that time. He was. Yes, he could just go into the restaurant on a daily basis and taken care.
She hadn't made the arrangements yet for her other businesses
Yes.
to be looked after by others. So she couldn't be there on a daily basis, so she temporarily put
Yeah.
her partner in, Miss Suzgun, until she was ready to take over day-to-day responsibilities.
Yes, that is correct, yes.
Yeah. Thank you. You've given evidence that you found out about the Home Office visit in March.
That's doing the needs. But did you actually find out about it in January?
Yes, I have found out the visit by the Home Office in January, but I found out a civil note penalty was issued. There were some illegal workers were found on the premises in March. It was just like me to, yeah, So it was just me taking action, what, I'm responsible to be a premises license holder and as a DPS. But when I found in March, it was basically there was illegal workers were found and he's been fined about it.
Thank you. Your partner Mehmet, what was his fault?
Well, not very much, and remember, it's like, ever since we made a change to our location, because I moved to Medway town in 2021. And that was the reason I had to give the responsibilities and lease it out to someone else. And because he's still got Mehmet runs the business as well, he's the director of the shop. And he goes to the island every single day. It was just like having Hobie, and he was visiting the restaurant on the weekends. And just, but nothing, he wasn't involved in a business professionally or on any papers.
Thank you. In the Home Office paperwork they've provided, the workers identified as
We've made that inquiry. It's not this Mehmet, different Mehmet. Additional notice. Mehmet is a bit like being called John, very commonly.
Thank you, Chair.
No further questions? No, I have no further questions.
Chair, I do have some questions for the Home Office.
Okay. Thank you. Okay.
Thank you very much. Mrs. Taylor, I just have a couple of questions.
Yeah.
From what we've heard. Firstly, you've had an opportunity to see the proposed conditions that are being put forward. Do you have any comments on those?
Not really. I mean, for us, I think we're still seeking revocation. I mean, all right to work checks of employees should be being done anyway. Granted, not by the license holder herself, but they should be being done. So putting that in there, can't see it making any difference really, because there's still the opportunity for illegal workers to be employed.
Thank you. And clarify, the Home Office recognises that Delicitas as responsible here for yes, and failure in respect of Mrs. Akers to vary the yes.
Yes, I think, again, I'll make the point that the employment and the licensing are two separate things. There's plenty of businesses where the license holder might not necessarily be in charge of employing and they sort of somebody else, but they are still responsible for upholding the licensing objectives.
So the civil penalty notice was issued to EDT, which is Delicitas is no longer involved.
That is correct.
Are there any other steps the Home Office may take against Delicitas?
Not personally, I believe it will be taken against the company. The last, I've just double checked, the last we've got, or I have access to, is that the penalty remains outstanding and it's been referred to a third party agency.
Jim, my last question was, do you know who Eric Mentor? Eric Mentor, the current officer and shareholder for EDT?
No, it's the answer.
Councillor,
Chair, because this man had a little embarrassed, you might mention of the employment checks, the license holder will be having those out in the future. Is that personally, or would you still be using the housing firm to carry out the license, the employment checks?
What will you do? I think it's been discussed between Mr.
Yes.
Studd and.
Yes.
So Mr. Studd, what's the idea?
So when I spoke to Miss Akers previously, she said that she would go back to the system she successfully used, which was the accountants. And as I say, I did speak to them and they do carry out regularly checks for a number of clients. So not just Miss Akis, and they confirmed that they had done that in the past and they would do it again in the future.
They are willing to carry on doing that
Yes.
on the company's behalf.
Yes.
Right, I'm going to ask the Home Office of Immigration Enforcement to summarise her case, please.
Yes, thank you, Chair. So in summary, you know, we found 3 illegal workers at the address. Whilst we appreciate that the DPS at the time had leased it out to another company, she had remained as the DPS, so she had a responsibility to ensure the licensing objectives were upheld, and she clearly understands that, because as soon as she found out, she then started taking measures to try and uphold the objectives. But my question would be is, why did it take a serious incident like this for her to suddenly realise her responsibility? She should have known it from the start, and she should have either transferred it prior, or she should have been taking steps to make sure the objectives were being upheld. So obviously the license section 182 guidance 11.27 outlines certain criminal activity that may arise in connection with licensed premises, which should be treated particularly seriously, which includes illegal working and somebody who's disqualified from work by reason of their immigration status. And then point 11.28 states that where a review arises from such activity and the licensing authority determines the crime prevention objective is being undermined through the premises being used for further crimes, it's expected that revocation of the license, even in the first instance, should be seriously considered. Obviously, all of that being said, we do recognise that our role is to bring the concerns to your attention. You're the local licensing authority. It's your area. You answer to the local electorate and you represent the interests of the local people. So we can only advise on what could happen. But other than that, I have nothing more, unless you've got any more questions that you want me to answer.
Thank you very much. Could I ask you to give us a summary?
You've seen Mrs. Akis is ashamed to be here. She is deeply upset. And the tone of anger you heard in her voice is towards Mr. Deliclitas. She placed her trust, as it turned out, in the wrong person. And she did carry out supervisory role she now realizes she ought to have done because she couldn't. But more important for your decision, hopefully she comes across as someone who is determined to put this right. There will be robust procedures in place to do so, which you can condition with the 3 conditions I've proposed. And you have a track record of Mrs. Akis running this venue her way from 2018. She took the license in December 2017, but the restaurant opened in 2018. For 4 years through to 2022, without a single issue, carrying out checks, and indeed you have the letter from the accountant saying that in that period they carried out the checks, something she takes seriously. So she has the ability and track record to get it right. This one mistake she made as a fallible but responsible human being should not define her forever. So we ask you please to give her a chance, continue to get it right, which her running the venue, and hopefully it will be one step back to restoring her reputation in the community she loves. And those are our submissions.
Thank you very much. Getting members of the final right, we will now adjourn to make our decision. And all those in attendance remotely should remain logged in to the meeting. Thank you everyone for waiting.
We've come to a decision. Our legal advisor will read that out to you.
Thank you, Chair. The licensing committee have decided to modify the conditions of the business license. They're going to add conditions, which are slightly amended from the ones that were included in your pack. So they're as follows. You will receive these in writing. Mr. Ahern Denikas shall not be permitted to work at the premises either directly or indirectly. The next condition. Ensuring compliance with and completion of right to work checks of employees shall be the responsibility of the licence holder. Thirdly, for a period of no less than 18 months, the licence holder shall arrange for independent professional inspections of the premises without warning at least once every 3 months. The inspector shall check compliance with licence conditions and confirm the right to work of all employees and make a written report after each visit. These reports shall be kept at the premises and made available for inspection on the request of an authorised officer over responsibility, and the reports must be sent to the licensing authority within 7 days of receipt by the licence holder. The licensing subcommittee are also going to issue you with they consider your actions as designated premises supervisor and all of the expected standards. And moving forward, you must ensure you're familiar with your responsibilities as a retailer of alcohol and as an employer within the hospitality industry. The written reasons for this decision will follow within 5 working days, and that sets out how they came to their decision. Within all the other matters today. That will also include price and party exit.
Thank you, everyone. I will now close the meeting at 11:57. Thank you, everyone.
Councillors, thank you for your consideration. Can I confirm we're happy to accept service by email? Thank you, everyone.